What's up, y'all? Welcome to the Shontavia Show, where my goal is to help you start a business based on your life's vision. This ain't gonna be your daddy's business advice. I'm laser focused on entrepreneurship in the 21st century, vision, and breaking the traditional mold. If you can get with that, you can get with me. Be sure to visit shontavia.com for more episodes, blog posts, and other content. Thank you for listening. The show starts now. Hey everybody, this is Shontavia Johnson, and welcome to another episode of the Shontavia Show, where I want to inspire you to build a brand, business, and life that you love. And I am incredibly grateful to have with me today Professor Wendy Greene. Wendy, thank you so much for being here.
Thank you so much for having me.
Yeah, so I don't know how many of you have been following the news about natural hair discrimination and all of the things that have been happening these past, couple of years with like hair love and with all these viral stories about kids and grown-ups at work and at school having issues and being discriminated against on the basis of their natural hair and the way they're wearing their hair. And Professor Greene's work for the past, nearly 2 decades, has for the past 2 decades been working to eliminate and ban natural hair discrimination in the workplace and in schools. And the new laws that have been passed in the past, 6 or 7 months are founded really on Professor Greene's work. She is one of the world's leading legal experts on this global civil rights issue, and she's been everywhere from Teen Vogue and the Washington Post to BBC World News, and I think I saw an announcement about you at Afropunk. Was it Afropunk?
Yes.
So you've been everywhere. And Professor Greene also has a forthcoming book called Free the Hair, Locking Black Hair to the Civil Rights Movement. And she was recently in conversation with Dr. Angela Davis as part of a virtual event where Professor Greene presented Dr. Davis with the Fred L. Shuttlesworth Human Rights Award. So is there anything, Wendy, that you don't do?
I don't sleep very much.
You know what? I could see that. I could definitely see that. So like this podcast is primarily about entrepreneurship and building businesses and brands. And the thing that I love about your work is you've built a movement. You've built a movement and a brand and a business or building a business. You've done all of these things. And I'm wondering about your story. How do we get to this place in 2020? What is your story?
What is my story? Well, we probably don't have enough time to get into the entire story, but in terms of the Free the Hair movement and campaign, like you mentioned, for me, essentially growing up as a child of civil rights activists in Columbia, South Carolina, it's pretty much deeply rooted in me to try to redress forms of racial injustice and inequality. And that is what really triggered me to go to law school. And while I was in law school, as you know, I came across, these set of cases that basically declared natural hair discrimination, except for the cases of afros, not a form of race discrimination that would violate our federal civil rights laws. And from learning about what I felt like was a racial injustice and a form of racial inequality, I just endeavored to learn more and to try to better understand how did we get to this point where our federal courts were not viewing other forms of natural hair discrimination that did not necessarily involve afros as a form of race discrimination. And so when I decided or really pursued becoming a legal academic and a law professor, the first article I wrote was about trying to get the federal courts to understand that discrimination on the basis of mutable characteristics like our hair, like our accents, our dress, our names even, can animate racial discrimination and really try to bring about a legal paradigm for these federal courts to recognize and appreciate and ultimately declare that this is race discrimination. So fast forward, I just built a body of legal scholarship. I published several articles really advocating that natural hair discrimination is a form of race discrimination, and that our federal civil rights laws should protect against this discrimination, namely in the workplace, but obviously beyond that. And then that legal scholarship, those legal writings, what I ended up doing was really just, um, you know, uh, from legal publications to actually action. And so talking with legislators, policymakers, lawyers, judges, students, even, and anyone who will absolutely listen to me, from 5-year-olds to octogenarians. I talk about this issue, and really trying to raise public awareness around it so that it can stop on personal levels, but also that it can stop in our professional educational spaces and beyond.
Oh, that's incredible. And so you mentioned being the daughter of civil rights activists. What is your parents' story? What is their background?
Sure. So my father, well, both of my parents actually were involved in the civil rights movement during the 60s as college students. And my father was arrested for his participation in the sit-ins in Columbia, South Carolina, as a student at Benedict College, which is a historically Black college in Columbia. And I learned about his arrest when I was 5 years old. And that's what really, for me, and I learned about it by actually reading, I don't know if I told you this, but reading a book about African-American pioneers. And in that book was Thurgood Marshall. And of course, one of the major accomplishments of Thurgood Marshall is that he argued Brown versus Board of Education and other cases to desegregate on the basis of race in a lot of spaces. So learning about Thurgood Marshall is then how I learned about Jim Crow, and then learned about how my parents grew up in the Jim Crow era and what that looked like and what that experience was like. And that's when I learned about my father's participation in the sit-ins, and that he was arrested for his participation, and that his case for criminal trespass, his conviction for criminal trespass, was overturned by the Supreme Court, United States Supreme Court. My mother likewise participated and supported the sit-ins, and also was involved in voter registration drives throughout the South, which it seems pretty commonplace today, but it was actually very dangerous, to travel throughout the South and try to enlist people to vote. So that was her participation, one of many forms during that time as a college student.
Wow. It's interesting to have that background and have that story. My mother integrated her elementary school in South Carolina, small town in South Carolina. And she would tell us these stories as we got older. And I just remember looking at her and learning about this stuff in school a little, and learning about it more at home, really, and feeling just this obligation to do well in school, to pursue justice, to work toward the elimination of oppression, even as a small child. And it sounds like you had a very similar experience, seeing your parents' stories and thinking, this is the kind of work I want to continue to do too, which is amazing.
Yes, I know, absolutely. Yeah, I felt it was so wrong. I remember 5 years old just feeling like that wasn't right. And I'm going to do something about that.
Right, and do something about it. You did.
Yeah, exactly. And I thank them for encouraging me, for me to even see myself as a person who could ultimately, maybe not simply become a lawyer, but to become a lawyer, to pursue higher education and pursue whatever my goals were going to be as a child. At that time, I thought I would be a Supreme Court justice or the United States president. Actually, I wanted to be the first Black woman Supreme Court justice. Okay. And sadly, that opportunity may still present itself, unfortunately.
Right. That could still be you. And please run for president.
Oh, no, thank you. That won't happen. So basically, very similar stories in terms of our childhood and having that village of people who are encouraging your dreams.
Right, encouraging your dream. And it sounds like you set out on that path as a 5-year-old little girl. You went to law school and you learned about this law that you disagreed with in law school. And you
Mm-hmm.
mentioned that your first article that you wrote as a law professor, as law professors and many professors do, they have to write either legal scholarship if they're law professors or academic scholarship of some sort, depending on the field they're in. You wrote about this topic.
Mm-hmm.
And how many years has it been since you've been really pursuing the elimination of natural hair discrimination? Has it been your entire career since law school and since becoming a law professor?
Definitely, yes. So let's see here. I was a crazy person and went to law school twice. So, so I got my JD from Tulane and then got my master's in law from George Washington University School of Law. And during my time as an LLM student, I concentrated on employment discrimination and comparative slavery and race relations law. And it provided me with the opportunity to build my scholarly profile and to write the articles that then would lead to publications. And so in 2005, when I entered the program, but I'd already decided what I wanted to write about, but when I entered the program definitively, that was the first article I wanted to write. And at that time, what was going on was the grooming policies that the NBA had instituted about, the players not being able to wear certain jewelry and certain clothing. And of course, there was a lot of critique about these grooming or appearance that would be associated with Blackness. Mm-hmm. And for me, I felt like really trying to interrogate what is it in our legal doctrine that is stopping us from having certain types of civil rights protections as it relates to race discrimination on the basis of appearance, whether it be our clothing, our hair, our hairstyles, hair texture, our names, and so forth. So I wrote the first article, Title VII, What's Hair and Other Race-Based Characteristics Got to Do with It, starting in 2005. It was published in 2007. And since then, I have written published three more articles under the auspices of what I call grooming codes discrimination. Mm-hmm. And now I've presented on grooming codes discrimination and natural hair discrimination all over the world, from Brazil to India to Cuba to Canada, and like I said, to any kind of organization that will hear me. And I also have a class. I think I'm right now the only class on appearance and grooming codes discrimination. So essentially, I've built not only the campaign but also the body of legal publications, but also legal training. Built off of this inquiry into grooming codes discrimination, in particular race-based grooming codes discrimination.
No, so I saw you on that circuit. It was maybe 8-10 years ago. I don't know. I think we were either in Boston or Wisconsin or something. I don't actually remember where. And I heard you talking about this topic then. And I was a brand new law professor, didn't know anything about anything. I was basically just taking all the advice from everybody about what to do and what not to do. And one of the things I had been told not to do, suggested multiple times by many colleagues, was not write about the intersection of, in my case, intellectual property and entertainment law and race. Mm-hmm. And people telling me that could be detrimental to my long-term legal career. But when I saw you talking about those things, it really, like, the light bulb went off, and I saw, well, this person is doing it. I think were you in Alabama at the time? You were at
I was, yeah.
Yeah.
I was at Cumberland at the time.
Yes, that's right. And I was just so motivated to just hear you. I don't think I ever told you that, or maybe I wrote you a thank you note or something.
You did.
Okay.
I loved it, and I loved it.
Great. I was good at thank you notes back then. But I was so motivated by your work, even then, to see that you were doing that, writing about those things and talking about those things. I had no clue that it would turn into this entire movement at that time. Did you know that your work would turn into a national movement, new legislation, hashtags, international awards, and all these things?
I felt, or at least I hoped, that the legal scholarship would ultimately change the law. And I will tell you, my initial focus was on the courts, and namely the federal courts, and trying to get them to interpret what I would say appropriately and interpret our civil rights laws in a way that really reflected the kinds of discrimination that was happening on the ground, and to protect and to afford protections against that kind of discrimination. So I definitely set out to change the law, but again, like I said, it was, the federal courts were really my focus. And then, as you know, it's challenging to get the federal court to adopt more progressive and sometimes expansive ideas about equality. And so my focus did shift, and it shifted to legislators and policymakers, to lawyers who were taking on these cases that would challenge natural hair discrimination as a form of race discrimination, or sometimes race and gender discrimination, depending on the context. And also starting to actually incorporate my work in my teaching. There was a time when I didn't necessarily teach my own work. And so then that, to me, I felt like I was training the next generation of lawyers to think more critically and deeply about the ways in which grooming and appearance codes do implicate civil rights laws and bring about inequality in workplaces and other spaces. So I wrote letters actually to members of the Congressional Black Caucus back in, I think, 2013, 2014, advocating that we needed to reconsider the Civil Rights Act of 1964 in particular, and think about amending it, and namely to actually define race that would encompass discrimination on the basis of natural hairstyles and hair texture. So the letter writing campaign started back in 2013. And then what we see now in 2019, the Federal Crown Act was introduced by Congressman or U.S. Representative Cedric Richmond and United States Senator Cory Booker of New Jersey. And I have to say that I had the immense privilege of being able to co-draft that federal legislation that was introduced. Did I know exactly how all of the pieces to this puzzle, how they were all going to fit together? No. But definitely getting out there and talking to those who are in those positions to actually make the change, and feeling, I think, confident enough to say, hey, I think you need to pay attention to this, is something that I did do. And so it's, shifting your attention. It's like, okay, if I can't get this body to do it, we'll just have to shift to other bodies. And thankfully, what has happened is that, obviously state legislators, I think, learning about the legal precedent, the unfortunate legal precedent where we have, natural hair discrimination not being treated as race discrimination. And as you mentioned before, all of these different types of discrimination that was happening in schools, likewise prompted, the state legislators to act and to fill this gap in civil rights protection that the federal courts had permitted.
So I feel like you just laid out a blueprint of building a movement and building a brand, because I think today in particular, so many people, when they're building a new thing, no matter what it is, a business, a brand, whatever, a movement, a website, or whatever, they want the first thing to work. And if the first thing doesn't work, it feels like failure, and it feels like, well, maybe I just shouldn't do this thing. But your story and the way you just laid that out is such a testament to your resiliency and to being flexible, right? Because not everything's going to work. And you mentioned starting with the federal courts and that not working. So moving to legislators, moving to policymakers, and to public sentiment too. And am I right that there have now been federal courts that have cited to your work and used your work in other ways? So it still came back around.
Yes, it did. So actually, I will say there is a happy ending sort of to the story, is that, yes, the Ninth Circuit actually endorsed my definition of race that I proposed in the 2007 piece that I mentioned earlier, which basically that definition of race is what is the definition of race, or at least a formulation of that definition is in the Crown Act. And so I wanted the federal courts to adopt it for the purposes of federal civil rights laws. But what we see is that state legislators and their legislative staff have adopted that definition of race for their particular civil rights laws that we now know as the Crown Act. And then what has happened is that the Ninth Circuit Court of Appeals has endorsed the definition of race for the purposes of constitutional decision making. And the 11th Circuit, even though the case that really EEOC versus Catastrophe Management Solutions, which has received a lot of attention over the past few years because it's the last decision of a federal court that declared discrimination against an African American woman who was wearing dreadlocks, and the rescission of a job opportunity or a job because she adorned dreadlocks did not constitute unlawful race discrimination in violation of our federal civil rights laws. So that case, when it was decided in 2016, really prompted a lot of media attention and got the attention of a lot of individuals who likewise thought this was an unfair decision. And even though the 11th Circuit ruled in that way, what I will say is that they did cite to the article as an authority on the construction of race, the social and legal construction of race. And then later, when this case was being decided by the entire 11th Circuit, we do have, for the first time to my knowledge, 3 federal court judges who did say, they're in a dissenting opinion, that discrimination on the basis of one's dreadlocks and the African American woman's dreadlocks in this hiring decision could constitute unlawful race discrimination. And the doctrine that has been used has been serving as a barrier in these cases. I have argued in my work that it is a legal fiction. And what I know is that the federal court judges in that dissenting opinion, they likewise call that doctrine a fiction. And so I'm pretty certain that the article, and among other articles that I had written, actually shaped that opinion. In part, I know this because, or I feel this is because I had, thinking about all the different ways that you can attack a problem, right? So I had actually co-drafted an amicus brief or a friend of court brief with the NAACP Legal Defense Fund, Dean Angela Onwachi-Willett, who you know, in the case, in the EEOC versus Catastrophe Management Solutions case, to say, hey, 11th Circuit, please reconsider this case because it is a form of race discrimination, or at least it could be. And then I was asked by the University of Miami School of Law to write an article about recent or pending 11th Circuit cases. Well, this case was still pending when I was asked. And so I said, well, this gives me another opportunity to talk to the court because I know they're going to have to read this. The 11th Circuit judges will have to, and they hadn't yet decided, whether or not they were going to hear this case en banc. So I wrote another article, and that's where I called the immutability doctrine, that legal doctrine, for the first time, a legal fiction, and that it was one that needed to be eliminated from our federal civil rights jurisprudence. And then one of the dissenting justices, one of the justices who signed on to that dissenting opinion a few months later was the justice who actually wrote the introduction to that 11th Circuit issue in the University of Miami School of Law's Law Review.
Wow. Okay. So things come back around.
You're right. So we now at least have 3 dissenting justices, federal court judges, mm-hmm. who have at least affirmed that, natural hair discrimination in all cases, not just limited to those where we have discrimination on the basis of afros, can potentially violate our federal civil rights laws.
Gosh, that's amazing. So you continue to plug away and you're building that support case by case.
You're right. And that's what it's going to take. It's basically the strategy. Our civil rights litigation strategy is that you have to chip away at it, right, at every little bit, every case by case. And it's change over time. It's not going to happen overnight at all. And trying to do it from all different angles and perspectives too.
So I'd love to explore that a bit, because you've built this movement based on the law and based on this definition of race that you've crafted. You have talked to any number of legislators, policymakers, and that kind of thing. And the other thing you've done, in addition to building this movement, which really nobody owns a movement, it is a collective opportunity for activity to move in a positive direction. You've also built this brand, the Free the Hair brand. It's got a hashtag, it's got a website, it's got a trademark, it's got all the trappings of a business. And I wonder how you have built this Free the Hair movement in a way that does another thing that we haven't really explored yet, which is change public sentiment, because you've also done that. And we see, like kids on Ellen who have been kicked out of school or suspended for wearing dreads, or you see little girls having their hair unbraided at school or cut by their teachers. So public sentiment is often also shifting. So how have you done both of these things? It seems almost simultaneously, building the movement, but then also building the brand of Free the Hair.
Right. So I will say that in terms of building the brand, figuring out what you're going to call it. And when I called it, Free the Hair, and I think I've mentioned this to you before, it really came about very spontaneously. And where one of our mutual friends, who's a law professor, her daughter saw a picture of me with my hair, and it actually looked like yours. So when you first met me, my hair looked like your hair. And she was so amazed by it. She says, "Mommy, I love her free hair." And that in and of itself really was so inspiring and touching to me. And I think, it's not to sit here and say that you don't recognize that people, children are looking at you while you're doing this work. But I think it let her know that you can rock your hair freely. And as it grows out of your head, and also occupy the space. And that you should be able to do that and occupy the space. And in this space, we're talking about being, a legal academic or a law professor. So from there, because I love that so much, I said, "Oh, Free the Hair. That's what we're going to call the thing," like kind of the Free the Hair movement, if you will. And so we started joking about that. And people started saying, "Oh, Free the Hair, Free the Hair, you're the Free the Hair professor," kind of thing. And then as I, like through Facebook, and then later through Twitter, and more recently through Instagram, and now through the website, anytime that I would promote information or public awareness around grooming codes discrimination, in particular natural hair discrimination, whether it be an article or some kind of documentary or even my own publications, I always use the hashtag Free the Hair. And so then that hashtag started to be used with, especially among the followers of, these incidences of discrimination that were happening around the world. And also making connections with other advocates and activists too in this space. Throughout the world, really trying to, it's not just about those people who are in the United States who are doing this work, but I really try to connect with people globally who are doing the work. So for example, I follow Zuleika Patel, if you know her. She's like, to me, I told Dr. Davis, she's my little Angela Davis, South African student who challenged, the grooming policies, the natural hair bans in her private high school. And so I follow her on Instagram. She now follows me back. So, it's those types of things, like really trying to connect with those individuals who are part of advancing and advocating for civil rights protections, as well as new policies as it relates to natural hair discrimination. And they started using the hashtag as well. And other folks, just, everyday folks who are using the hashtag. And so I would say the power of social media and actually getting outside of my my box a bit in terms of, and also being consistent in using the hashtag, and being consistent in the message that you're trying to send. So now people know if they want to know about this subject matter and what is currently going on, not only in the United States, but around the world as it pertains to this issue. They know you can go to my social media platforms, or you can email me, or you can call me, and I can give you the latest as it relates to that.
No, that's phenomenal.
Yeah.
That's great.
So that's how it's come about. And yeah, so I mean, social media has been huge as it relates to that, but also still doing that in person. I don't want to, really try to erase the importance of in person. Well, now I know during COVID times it's more challenging to do that, but really taking those opportunities to talk to any community. So I don't just speak to just purely legal academic or just academic community, speaking literally to middle schoolers, elementary schoolers, high schoolers, as I said, community groups that of retirees, whoever will listen. I'm out there to try to promote the message.
So as you do that, as you're connecting with all these different groups, are there connections between your work and the recent work of Black Lives Matter and these instances of police brutality against African Americans? Are there parallels or connection points where the two movements can learn from each other and share this common interest of improving the lives, particularly of African descendants and other Black people?
Oh, absolutely, absolutely. They're definitely in concert with one another, and I imagine that this area of discrimination may be one that is overlooked as it relates to the demands that Black Lives Matter advocates may be advancing at this point. But it is actually a critical one, because essentially when we're talking about natural hair discrimination affecting and systematically affecting African descendants around the world, we're talking about a long-standing form of policing the Black body. So even if we go back to the eras of racial slavery, our hair was being regulated. It actually signified whether or not we were enslavable or free. Also, our hair was being regulated to signify that we were not free. So if you know about the Tenyon laws, in Louisiana, where women of color, in particular African descendant women, had to cover their hair, so it could signify their socially and politically and legally constructed status as being subordinate, or legally constructed subjugated status, right? And then till today, we see this what I call hyperregulation of Black people's bodies via our hair in a number of spaces, and more recently, and we're subjected to a heightened level of punishment, and because of our natural hair. There's plenty of studies that talk about Black women and men who wear natural hairstyles, that in criminal proceedings, that they may be more likely to get a heightened sentence
Wow.
or an increased sentence than those who have short hair if you're a man, or if you have straightened hair if you're a woman. Right. So, and if we're talking about, these pipelines to prison issues as it relates to our children, our children are being subjected to greater levels of punishment that then lead to, that then can potentially lead to this entry into our criminal justice system. And so that's something else. And then thirdly, more globally, there has been, recent studies, actually a recent article just about 2 weeks ago that talks about in Brazil, for example, now there is an awakening, a movement similar to what's going on in terms of natural hair movements and its relationship to Black Power and Black Lives Matter. It's even very much a specific part of the Black Lives Matter movement in Brazil. And one of the things is as more Afro-Brazilians are wearing their natural hairstyles or their natural hair texture in afros and locks and braids and twists, one of the concerns of Afro-Brazilian parents is that. because they're not only are they being attracted, or police are attracted to them, and policing them in a harsher way because of their skin color, but also because of their hair texture.
Wow.
Yeah, so there's definitely a real vital connection to the Black Lives Matter movement, and I think it's absolutely a part of the Black Lives Matter movement. It should be a part of our demand. So that being said, we should be talking with our legislators about passing the Crown Act if they haven't already, or introducing the Crown Act, and even more broadly, our federal legislators, our national legislators, because that bill has been introduced. And so as we're thinking about the demands, right, and creating the demands for racial equity, and namely racial equity as it relates to African descendants, this is a critical part. This legislation is a critical part of that.
So how can people, two questions, how can people do that? I know there's a petition. I think there's a petition, right,
Yes.
to tell your legislators that you want them to introduce and or pass this legislation into law. So that's the first question. And then second question, how can people connect with you? How can they find your work? How can they learn more about Free the Hair?
Sure. So you can go to the Crown Coalition .com or thecrownact.com, I believe, is the website where the general petition is. And that is being sponsored by Dove and the Crown Coalition, which is a group of organizations who are supporting the Crown Act, among other forms of policies that are affecting or trying to bring about racial equity. And then you can email your legislators. You can write your legislators and bring this to their attention. And again, seeking whether or not they have already introduced it or thinking about introducing it, and if not, then that they should start considering and actually do so, right? And you can even create your own petition. There is the one that's online, but you can do that too, and mobilizing and getting your own petition and getting signatures, so that the legislators, the policymakers, can see that there is a body of their constituents who are really who are advocating for this legislative change. Another way, a way to reach me is you can go to FreeTheHair.com, which is the website, and also you can follow me on Twitter at Professor D. Wendy, as well as on Instagram at Professor D. Wendy, and also at Free the Hair Now on Instagram and Twitter.
Excellent. This was so much fun. I'm so excited we had the opportunity to talk about this, about you actually building a movement and doing what many of us say we want to do, which is change the world. You actually are doing that and have done that. And so I just so appreciate the conversation.
Oh, well, thank you so much again for having me and allowing me to talk about all things Free the Hair. It's such a pleasure, and I'm so glad that we were able to make this happen.
Great. So for those of you who are listening or watching, if you have questions, if you have comments about this particular topic, about building movements or building brands, feel free to visit the website at Shontavia.com to drop a comment, leave a message about this specific episode. If you'd like to connect with Professor Greene, she's given you all the various links. I will also drop some links in the show notes to everything she mentioned. If you want to learn more about the Free the Hair movement, about the Crown Act, and about ways you can get involved. Thanks. Thank you so much for listening to this episode of the Shontavia Show. If you enjoyed this episode, please be sure to like, subscribe, and leave a comment wherever you're listening. You can find me on social media everywhere, Facebook, Instagram, Twitter, LinkedIn, and wherever else at Shontavia J ESQ. You can also visit me at Shontavia.com to find a transcript of this episode, along with other show notes. While you're there, please be sure to subscribe to my email newsletter. The information shared in this podcast and through my other platforms is designed to educate you about business and entrepreneurship, and I love to do this work. While I am a lawyer, though, the information I provide is not legal advice and does not create or constitute an attorney-client relationship. The Shontavia Show is a Leverage Incorporated original. The show is recorded on site in South Carolina and produced at Sit and Spin Studio in Greenville, South Carolina. Original music and sound design is by Matt Morgan and Daniel Gregory. Mixing and mastering is by Daniel Gregory, and the video is by GVL Media.